Okay, g'day students. Here's a quick rundown of dot point 4.7, the status of international covenants, protocols and treaties in protecting human rights in Australia. So please note guys, there's a bit of a limit to this, which is good for you. There's less to actually prepare for this exam. The key word here is status, the status of these things in protecting human rights in Australia. So I'm assuming that that's what the questions will be limited to if you get this topic in the exam. So anyway, starting point, you need to know what covenants, protocols and treaties are. So we shall begin with a definition of what a treaty or a covenant is. Treaties and covenants are basically the same thing. Convention is also used sometimes because it's referring to the meeting that was taken place at the international level. But since convention is not mentioned in the syllabus, you'll probably only get to come into contact with these words, covenant and treaty. So the key elements here for this definition is you have to obviously recognise that it's binding, agreement between two or more states. And by states, of course, we mean at the international level an entire country. So they are legally binding, and countries that sign it are basically signalling an intention to ratify this agreement in their own domestic law, even though that's not guaranteed, of course, with many countries observing the separation of powers. And if countries do agree to be bound by a treaty or a covenant, it is a possibility that to subsequently violate these agreements, the UN could censure you, or even, if passed by the General Assembly and the Security Council, issue sanctions against you, although that's highly unlikely, especially if you're a country that has veto powers on the Security Council. So I probably should note that violations, if bound, can have consequences. All right, the other word mentioned is protocol. And protocols are also binding agreements between states. However, they are optional. Okay, optional additions, if you like, to the treaty or covenant. So they're related to an already existing agreement, and they're just optional extras. A little bit like you've committed to having a McDonald's burger, and then of course the McDonald's ask you, would you like fries with that? And of course you are free to say yes or no to the additional protocol. But if you do agree, they're just as binding as treaties and covenants. So they're additional and they're optional. Those are the key differences between a protocol and the other two. Okay, so those are the definitions out of the way with. Now on to their status in Australia. So let's go to status. So it depends, of course, if Australia signs up and then ratifies it. So those are the key steps, right? So we have step one is the agreement is made at the international level. Australia may have contributed to the formulation of that agreement, and Australia likes to sort of throw its weight around where it can, because it likes to see itself as a middle power in the world. So we have the agreement, and then after that, countries sign up, and that is the executive, the second arm of government, indicating a commitment to the agreement. Okay? However, it's not legally enforceable in Australia until the Parliament, the first arm of government, ratifies it. Okay? It passes either a piece of legislation mirroring the agreement through Parliament, or indicating or just an acknowledgement, a formal acknowledgement by Parliament that we agree to be bound by the treaty or the covenant. And of course, this may require codification. If we've agreed to be bound, and Parliament has agreed to be bound, so if the executive has agreed to be bound, the Parliament has agreed to be bound, and yet we don't have any laws yet that guarantees that we'll be bound by the agreement, then we may require codification, which is essentially just creating legislation which mirrors the agreement, the wording of the international agreement, and then passes that through the Parliament. So now we have an official domestic law which has confirmed our commitment, our legal commitment to the international agreement. Okay? So once you're there, now it is legally enforceable. So then we have a fourth and final step, which is once the rights exist legally in Australia, how are they monitored? And how are they enforced if there are breaches? Okay? And basically each individual member state is free to come up with their own systems here of monitoring and enforcement. Okay, so this fourth bit is, of course, the bit that's most interesting in terms of discussions on status in Australia. Okay, because we have signed up and ratified most of the key international agreements relating to human rights. I probably should. The big ones that you should definitely know going into the exam is the ICCPR, the International Covenant on Civil and Political Rights, and we got the International Covenant on the Elimination of Racial Discrimination, and we have the International Covenant on Economic, Social and Cultural Rights. Those are the three really big ones. Of course, there's the other discrimination, anti-discrimination ones as well, disabilities and women as well. You're free to memorise bits and pieces of those if you wish. But this one in particular, the ICCPR, is of course the most important because they give you your basic negative rights, which are needed for a functioning liberal democracy. Okay. So on to monitoring and enforcement. So Australia has developed a number of instruments to make sure that human rights are being respected in Australia. So the first one is we created a statutory authority called the Human Rights and Equal Opportunity Commission, which is an independent watchdog and arbitrator of any human rights disputes that may arise between citizens in Australia. And so yes, they're a bit of a watchdog. Okay, so they look out for any human rights complaints from citizens of Australia. They also are an advocate for human rights on our behalf. So for instance, they make submissions to Parliament if there are problematic laws that Parliament might be considering, and so forth. And of course, they have an education role as well to improve understandings of human rights in Australia so that we can better respect them. So that's a very important watchdog and serves a number of roles in respecting human rights in Australia. Secondly, we have a bunch of commissioners, so that's the Human Rights and Equal Opportunity Commission. Then we have commissioners, individuals who are given statutory powers to again be a triage for complaints and to also advocate for human rights in their particular area. So we've got, for example, a race discrimination commissioner. We have one just generally on human rights, the Human Rights Commissioner. We've got an age discrimination commissioner and a children's commissioner as well. So they're individuals that people can go to have their human rights complaints perhaps taken to a higher level. Now, something a little bit more recent is we have the Human Rights Parliamentary Scrutiny Act of 2011. And this act essentially requires all bills passed through Parliament to have a statement of compatibility. So it's forcing members of Parliament who are seeking to make laws that these new laws will be consistent with existing human rights commitments. And if not, they have to actually justify that with, why it's a reasonable violation or encroachment onto human rights. So a bit more, this forces our Parliament to be more constantly cognizant of human rights considerations. And on top of that, for human rights, we've also got the Joint Committee on Human Rights. Okay, this is 10 people, 5 from the Senate, 5 from the House of Reps, whose job it is to, investigate the human rights implications for laws that are being considered through the Parliament. If they're referred to this committee, of course, like all committees, you need to have these bills referred to you, and they'll then report back to Parliament what effect these bills will have on human rights. On top of that, in terms of enforcement, we've also submitted to the optional protocol attached to the ICCPR regarding reporting to the Human Rights Committee at the UN. Okay, so every 5 years we deliver a report, or our government will deliver a report on how well we're respecting human rights in Australia. The last one we did was in 2017. And then the Human Rights Committee will take this report on board and then give its findings on how well Australia is going with human rights. So essentially we report to the Human Rights Committee, and then the Human Rights Committee will give us a final report every 5 years on our human rights, how well we're going in human rights. And most recently, their report did give us a few ticks, especially in the areas of sex discrimination and recognising sort of gender diversity and things like that. But it did have a number of serious concerns about, again, our human rights respect for asylum seekers, victims of domestic violence. They also had a concern with that, problems related to that, and obviously ongoing concerns with the gap between Indigenous and non-Indigenous and the rate of Indigenous incarceration in Australia. So that was worth noting. Also, because we've submitted to the Human Rights Committee, if I may, people can go straight directly to the UN committee if they believe their human rights have been violated in Australia, and there's been a few notable cases here. So we have, of course, the first one that you should be thinking of is Toonan in 1994, I believe, where the committee found that the Tasmanian laws that were affecting Toonan, these anti-homosexual laws, were inconsistent with Australia's commitment to the ICCPR, and as a consequence, the Commonwealth Government overrode that legislation. Okay, so it was a Commonwealth over Tasmanian. So again, this is related to federalism. So the Commonwealth was quite prepared to make sure these laws were repealed by using their external affairs power to make sure that they were observing our commitment under the ICCPR. However, on the other hand, another case, Young, from 2003, where a same-sex couple was claiming a veteran's pension. I believe the case concerned the same-sex partner of a veteran now deceased, wanted to claim on the veteran's pension on behalf of the deceased, was unable to claim it when, if it had been a male-female relationship, if it had been the widow of this veteran, then they would have been able to get an ongoing pension. So this was seen as discrimination. The Human Rights Committee agreed, but to no avail, because even though the Human Rights Committee was sympathetic to Young's case, the Commonwealth Government just ignored it. So again, you can immediately start to see your evaluation here of whilst we seem to be doing a lot right with human rights, when it suits, particularly if it's a Commonwealth law and the Human Rights Commission is criticising a Commonwealth law, they're a lot less willing to repeal those violating pieces of legislation. Whereas if it's a state law, they're far more keen to override them, because it automatically sort of means an expansion of Commonwealth power at the expense of the states. Where else can we go here? Also, in terms of status, let's not forget court interpretation. Okay, this is again a very important aspect in terms of the word status. Okay, so human rights get increased status if our courts recognise them. So if we sign up to international agreements, the courts have a common law approach. Okay, common law approach, which says, in the absence of unambiguous language to the contrary, the courts will assume that all Australian laws are to be read, interpreted, so as to be consistent with human rights. So that's good news for human rights, right? It means if Parliament intends our human rights to be encroached upon, they have to actually really be super clear and admit it and say this is exactly what we're intending to do. So the courts are kind of forcing the Parliament and the government to be open and honest if they're intending to encroach on human rights. And that is, the authority for that is a case called Coco v. the Queen, from 1994. Okay, where the High Court said this is going to be our attitude to human rights in the common law. I think that just about does it. I will mention this joint committee. Okay, one more note on this committee. So this committee has been criticised for being pretty useless. Not to be confused with the UN committee, but the Joint Parliamentary Committee on Human Rights, the 5 members of the Senate and the 5 members of the House of Reps. For instance, they investigated the Racial Discrimination Act, in particular 18C, which has, of course, caused a lot of controversy, especially after the Bolt case, ETOC versus Bolt. And a few other high-profile cases like Bill Leak, the cartoonist, and so on. So the committee itself recommended that 18C be watered down, deleting a number of words, offend, insult, intimidate, and just have the word harass, which seems to me to be a much higher standard to prove that you are harassing people on the basis of their race. The Labor Party and the Greens, who were involved in this committee, strongly disagreed with this recommendation, but the recommendation went ahead anyway, and the Parliament attempted to officially change 18C in 2017, following along from this recommendation from the Joint Committee, but it was eventually shot down in the Senate. The Senate narrowly voted it down. The Greens, the Labor Party, the Nick Xenophon team, and Darren Hinch, I think, voted it down, so 18C has remained in its current form, but no thanks to the Joint Committee on Human Rights, which seems to be a valid criticism of the committee, that if it's controlled by the parties, and so if the party in power wants to remove the rights, they can get the Human Rights Committee to recommend it, which seems to be contrary to the point of having a committee concerned with human rights. One other note is, don't forget reservations. So countries can sign up to these international agreements with reservations. And so, for example, we have a reservation on Article 20 of the ICCPR, okay, which is about propaganda for war and incitement to violence. I'm not actually quite sure why we have reservations on this particular article, but we do, meaning I presume we're admitting at the international level that we're not intending to be bound by this particular article. So countries have the option to accept an agreement with little bits and pieces not agreed to, and as long as we do that and everyone's aware of it, it seems to be fine. Okay, I hope this summary was helpful. I hope I wasn't too verbose. I don't know how long I've been talking for, and I will be getting on to the next video as soon as I can. All right, all the best with your studies, guys. Cheers.